Welcome to The Docket. I'm your host, Corey Snow. This is episode 11. In August of 2023, Mark Meadows, who is a defendant in the sprawling Georgia RICO case that also includes former President Trump, has been attempting to have his case removed to federal jurisdiction, where he plans to assert that he has immunity from prosecution under federal law and the Constitution. On August 25, 2023, Meadows, through his attorney, filed a response to the Georgia prosecution's arguments against removal and immunity. What follows is an audio narration of that filing. Please note that to improve listenability, most citations are omitted. Those that are not have been simplified to stating only the name of the case. The original document, including all citations and footnotes, is available at a link provided in the description of this episode. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. In the United States District Court for the Northern District of Georgia, the State of Georgia v. Mark R. Meadows, defendant. Reply of Defendant Mark R. Meadows to the State of Georgia's response to his notice of removal. The state opposes removal because, in their view, Mr. Meadows did not act in his official capacity as Chief of Staff when he set up a call between the President and Georgia Secretary of State and took other actions alleged in the indictment. Thus, they say, those actions had no connection to his official duties, and Mr. Meadows does not have even a colorable defense. The state is wrong. There is no election or politics exception to the Supremacy Clause or the Federal Officer Removal Statute, and the state mischaracterizes federal law and the Chief of Staff's role. In any event, the state's arguments about Mr. Meadows' conduct and federal authority are properly considered once the case is removed, not on the threshold question of removal, which presents a quite low bar. Caver v. Central Alabama Electric Cooperative, 2017. Internal quotation omitted. The court should permit removal at or promptly after Monday's hearing. On Monday, August 14, 2023, the state charged Mr. Meadows on 2 state law counts as part of a 19-defendant, 41-count case under the Georgia RICO Act. See indictment. Mr. Meadows promptly removed under the Federal Officer Removal Statute, 28 U.S.C. Section 1442, the following day, Tuesday, August 15th. See Notice of Removal. This court declined summary remand on Wednesday, August 16th, and set an evidentiary hearing for Monday, August 28th, consistent with 18 U.S.C. Section 1455b5. The state has now responded to the notice of removal. 1. Mr. Meadows has met the low threshold for removal. Mr. Meadows is entitled to removal under 28 U.S.C. Section 1442a1 because he has met the very low threshold for removal by a federal official. It is undisputed that Mr. Meadows served as a federal official during the relevant period, specifically as Chief of Staff to the President of the United States. To obtain removal, he needs only to, 1, quote, show a causal connection between what he has done under asserted official authority and the action against him, end quote. Caver v. Central Alabama Electric Cooperative, quoting Magnin v. Teledyne Continental Motors. And 2, quote, raise a colorable federal defense, ibid. Those are easy showings to make, and Mr. Meadows has made them. First, it is clear from the notice of removal, the indictment, and even the state's response that there is at least some causal connection between the conduct charged and Mr. Meadows' role as Chief of Staff. The charged conduct all occurred during his tenure and as part of his service in that role. The conduct alleged in the indictment plainly came about because Mr. Meadows was serving as Chief of Staff to then-President Donald J. Trump, and the Chief of Staff has broad-ranging duties to advise and assist the President. This is not a case where the defendant was plainly, quote, acting on a frolic of their own which had no relevancy of their official duties, end quote. Willingham v. Morgan. Internal quotation omitted. And even if that is how the state wishes to characterize it, Mr. Meadows, quote, should have the opportunity to present his version of the facts to a federal, not a state, court, end quote, since, quote, this is exactly what the removal statute was designed to accomplish, end quote. Ibid. The lenient connection standard derives from the broad language of the federal officer removal statute, which covers any claims, quote, for or relating to any act, end quote, under color of federal office. 28 U.S.C. Section 1442A1. As the 11th Circuit has held, quote, the phrase relating to is broad and requires only a connection or association between the act in question and the federal office, end quote. Caver, internal quotation omitted. While the state disputes whether Mr. Meadows' conduct was actually required or properly considered part of his official duties, those arguments are more relevant to the separate issue of immunity. They do not negate a finding that the conduct had a connection to Mr. Meadows' official duties. Second, Mr. Meadows, quote, raises a colorable federal defense, end quote. Caver. The 11th Circuit, quote, gives this portion of Section 1442A1 a broad reading so as to encompass all cases where federal officers can raise a colorable defense arising out of their duty to enforce federal law, end quote. Ibid. In deciding removal, the court need not, indeed cannot, adjudicate the immunity defense on the merits. A colorable, quote, defense need only be plausible. Its ultimate validity is not to be determined at the time of removal, end quote. Magnin. See also Caver. Quote, the law does not require that the removing defendant virtually win his case before it can be removed, end quote. Here again, Mr. Meadows has cleared the low bar for removal. It is undisputed that the Supremacy Clause provides immunity from, quote, suits under state law against federal officials carrying out their executive duties, end quote. Cordash v. United States, including former federal officials who served at the time of their alleged conduct. See Maryland v. Soper. And again, it is undisputed that Mr. Meadows was a federal official at the time of the charged conduct. The only dispute the state asserts here is whether Mr. Meadows is entitled to immunity based on the nature of the conduct charged and the scope of his duties. To the extent that dispute might require resolution, it does not preclude the antecedent removal for which the statute broadly provides. On the merits, immunity turns on, quote, whether a federal official's acts have some nexus with furthering federal policy and can reasonably be characterized as complying with the full range of federal law, end quote. Cordash, internal quotation omitted. Thus, even at that stage, the federal official need not prove that he stayed within his lawful authority, only that he reasonably believed he was. As to removal, quote, the lenient, colorable federal defense requirement, end quote, focuses on the removing official's version of the case, not the state's competing narrative. Caver. Again, the court, quote, need not determine the merits of that position, end quote, in order to reach removal. Ibid. 2. The state's arguments for a political exception to the Supremacy Clause are without legal basis and therefore unpersuasive. While the state's characterization of Mr. Meadows' conduct and official duties are largely irrelevant at the removal stage, they are also wrong. Neither the duties of the Chief of Staff nor the laws and Constitution of the United States draw a clean line between federal authority on the one hand and elections and politics on the other. Indeed, creating an election or politics exception to removal and official immunity would have sweeping consequences for the role of Chief of Staff and the operation of the federal government going forward. While the court need not resolve the state's arguments against immunity to effectuate removal, those arguments miss the mark. The state's myriad specific arguments boil down to two general ones. A, that there is no federal authority to be involved in political activity involving Georgia's presidential election, and 2, that Mr. Meadows acted out of a personal interest to see the president reelected. A. Elections and politics do not fall beyond federal authority. The state argues repeatedly that Mr. Meadows has no immunity if his conduct related to Georgia's administration of the 2020 presidential election or involved politics. See opposing motion at 15, describing Mr. Meadows' conduct as, quote, unquestionably political, end quote, in nature, and therefore by definition outside the lawful scope of his authority as Chief of Staff, end quote. Ibid. Quote, the activities in which he assisted Mr. Trump were all unofficial activities concerning his efforts to remain in office for a second term, and there is no authority for a president or his chief of staff to take any actions concerning the administration of a presidential election, end quote. Ibid. Quote, the president himself had no authority of his own in the administration of the election, end quote. That notion is fundamentally flawed for several reasons. First, contrary to the theme of the state's response, the federal government has a substantial interest in the proper administration of federal elections, even though the states also play an important role. See, e.g., Electoral Count Act, 3 U.S.C. Section 5, Governing Process for Electoral Vote Counting and Certification by the States, Voting Rights Act, 52 U.S.C. Section 10301, Illegal to deny or restrict voting rights because of a citizen's race, National Voter Registration Act, 52 U.S.C. Section 20501, requires most states to allow registration to vote by mail. Uniformed and Overseas Citizens Absentee Voting Act, 52 U.S.C. Section 20301, governing right to register and vote absentee in federal elections. Help America Vote Act, 52 U.S.C. Section 20901, requiring use of provisional ballots in federal elections. See generally U.S. Code Title 52, Voting and Elections. Second, contrary to the state's claim, the Hatch Act does not put Mr. Meadows' charged conduct beyond the scope of his official duties, and thus beyond a colorable immunity defense. The Hatch Act is a red herring, particularly at this stage. Any dispute about the Hatch Act is a proper matter for the federal court after removal. Nonetheless, Mr. Meadows complied with federal law in connection with the charged conduct, and neither OSC, nor DOJ, nor any other competent federal enforcement authority has suggested otherwise, despite the intense focus and public nature of the alleged acts. The state points to an Office of Special Counsel report that discusses 3 interviews Mr. Meadows gave before Election Day about conduct entirely unrelated to the conduct charged here. Even as to those speeches, the OSC report acknowledges that the White House counsel's office defended Mr. Meadows, arguing that, quote, the Hatch Act does not apply, end quote, and that OSC's findings would, quote, violate employees' free speech rights under the First Amendment, end quote. Report at 27. OSC also acknowledges that for commissioned officers, like the Chief of Staff, quote, it may only submit a report to the President, end quote. It does not have enforcement authority. Third, the state cannot draw a meaningful distinction between the official responsibilities of the President and those of other federal officials whose duties indisputably relate to the administration of elections. Under the federal Constitution, quote, the executive power, all of it, is vested in a President, who must take care that the laws be faithfully executed, end quote. Saela Law, LLC, v. Consumer Financial Protection Bureau, plurality opinion, quoting U.S. Constitution, Article 2, Section 1, Clause 1, Ibid, Article 2, Section 3, Clause 3. The President, quote, cannot delegate ultimate responsibility or the active obligation to supervise that goes with it. Free Enterprise Fund v. Public Company Accounting Oversight Board. Internal quotation omitted. Thus, nothing is beyond the scope of the President's duty unless it is beyond the duty of the entire executive branch. Indeed, even if elections and politics were beyond the authority of the entire executive branch, the President, and by extension his Chief of Staff, would still appropriately inquire into them to the extent they fall within Congress's authority. Under Article 1, quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. U.S. Constitution, Article 1, Section 4, Clause 1. The President, in turn, plays a constitutional role in supporting this congressional function. Article 2 provides that the President, quote, shall from time to time give to the Congress information of the state of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient." End quote. Ibid, Article 2, Section 3. Thus, even for matters committed exclusively to Congress, the President still has authority, and indeed a duty, to inquire and to make recommendations. Finally, the state conflates 1. The distinction between the President's official and unofficial duties, including as a candidate, and 2. The Chief of Staff's duties as his principal assistant and advisor. See opposing motion at 15. Quote, "The activities in which Mr. Meadows assisted Mr. Trump were all unofficial activities concerning his efforts to remain in office for a second term, and there is no authority for a president or his chief of staff to take any actions concerning the administration of a presidential election." End quote. As Chief of Staff, Mr. Meadows did not stop assisting the president just because the president was doing something personal or political. To take one example, certain White House personnel must travel with the president and do so in their official capacities, even when the president travels to a campaign rally. One such essential traveler is the Chief of Staff or his designee. One would not say the pilot of Air Force One ceases to be a military official when he flies the president to an unofficial event. The same goes for the Chief of Staff. They do not take off their official hats just because the president takes off his. B. The personal interest principle does not apply here. The state also cannot stop removal by alleging that Mr. Meadows acted out of a personal interest in seeing President Trump reelected. Opposing motion at 15, quoting Baucom. "None of the 4 cases the state cites involve an alleged distinction between political and official duties, and they are wholly inopposite here. Baucom, the 11th Circuit case, involved an FBI special agent who, quote, had participated during the course of an investigation in an alleged bribery attempt of a Georgia state prosecutor," end quote. The Court of Appeals held that he was immune, even though he willfully violated Georgia law because, quote, his acts in the bribery scheme were within his authority as an FBI agent and any state conviction of him for those acts would contravene the Supremacy Clause of the Constitution of the United States. Ibid. The state cites a passage from the court's admonition that, quote, even if the officer makes an error in judgment in what the officer conceives to be his legal duty, that alone will not serve to create criminal responsibility in a federal officer. Ibid. The court found, quote, no suggestion that Baucom acted because of any personal interest, malice, actual criminal intent, or for any other reason than to do his duty as he saw it. His good faith cannot be seriously questioned, end quote. Ibid. Baucom does not remotely suggest that Mr. Meadows loses immunity if he wanted the president to be reelected. Rather, Baucom supports removal and immunity because it shows that he is protected so long as he had a good faith belief, even mistaken, that his conduct was within, quote, his duty as he saw it, end quote. The 3 out-of-circuit cases are equally unavailing. In Texas v. Kleinert, the Fifth Circuit affirmed dismissal of state manslaughter charges against a federal task force officer. The court noted that, quote, none of the evidence suggests that Kleinert acted out of personal interest or bore any ill will toward the suspect he shot, end quote. Ibid. In Reed v. Madden, the Eighth Circuit reversed denial of habeas relief to a federal agent indicted for manslaughter. The court noted, quote, that Reed, in good faith, believed that his life and the lives of those for whose presence he felt responsible were in danger, and that the action complained of here was taken in that belief, end quote. Ibid. And in Clifton v. Cox, the Ninth Circuit affirmed habeas relief to a federal agent charged with second-degree murder and involuntary manslaughter for a fatal shooting during a drug raid. In discussing the Ninth Circuit standard for Supremacy Clause immunity, the court stated that, quote, essential to this determination, assuming the truth of the state's evidence, is whether the official employs means which he cannot honestly consider reasonable in discharging his duties or otherwise acts out of malice or with some criminal intent, end quote. Ibid. Each case turned on whether the federal official fired the fatal shot in a good faith exercise of federal duties as opposed to out of criminal malice. They have nothing to do with the supposed line between official federal duties and unofficial political activity, nor do they remotely suggest that Mr. Meadows cannot claim immunity if he wanted the president to be reelected. See opposing motion at 16. Quote, the defendant shared a personal interest with Mr. Trump in seeing the Trump campaign achieve its goal of reversing Trump's electoral loss in Georgia. End quote. Like Baucom, these cases further support immunity, and thus also show at least a colorable defense for purposes of removal, because they reinforce that Mr. Meadows need not prove that his conduct complied with federal law in retrospect. He is entitled to immunity because he acted in good faith to further what he understood to be his official duties. 3. The allegedly broad scope of the Georgia RICO Act is irrelevant. The state finally argues that Mr. Meadows, quote, misapprehends the nature of Georgia RICO law and conspiracy law generally, end quote, under which it says, quote, an overt act need not be a crime in itself. Opposing motion at 19, quoting McWright v. State, citing Iannelli v. United States. That alleged misapprehension is irrelevant. Under Neagle, quote, entitlement to Supremacy Clause immunity is to be ascertained by looking only at federal law, end quote. The whole point is that a federal official carrying out his duties is not, quote, obliged to consider state criminal law at all before acting, end quote. Seth P. Waxman and Trevor W. Morrison, what kind of immunity? Federal officers, state criminal law, and the Supremacy Clause. 112 Yale Law Journal, 2003. Of course, the state does not cite a single case suggesting that it can overcome removal under 28 U.S.C. Section 1442A1 by charging a federal official under a state criminal statute that does not require a criminal act. There is no such case. Indeed, the state's apparently sweeping theory of liability only further underscores the importance of removal. Supremacy Clause immunity and the federal officer removal statute protect against, among other things, the risk that a state, quote, may administer not only the laws of the state, but equally federal law, in such a manner as to paralyze the operations of the government, end quote. Tennessee v. Davis. The state's assertion of the broad scope of the Georgia RICO Act against a White House chief of staff should be tested in federal court, not in state court. The court should therefore promptly remove Mr. Meadows' case and so notify the state court pursuant to 28 U.S.C. Section 1455B5. Dated August 25, 2023. Joseph M. Englert, McGuire Woods, LLP. Address omitted. Respectfully submitted, signed George J. Terwilliger III, John S. Moran, Michael Francisco. Address, phone number, and email addresses omitted. George J. Terwilliger III, John S. Moran, Michael Francisco, all admitted pro hac vice. George J. Terwilliger III is counsel to Mark R. Meadows. This concludes this episode of The Docket. I hope you enjoyed this audio version of Mark Meadows' response in support of his arguments for removal of his case to federal jurisdiction and immunity from prosecution. For updates on The Docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. Please consider subscribing to The Docket and supporting my Patreon at patreon.com/DocketPod. Thank you.